And that would be based upon your experience.
Based upon my experience, what you normally would do, the legalese would be go over the jury instructions, that kind of thing. I mean, I didn't find any constitutional deficiencies in their interaction with him. There was an objection to exactly what they talked about, and I didn't get into that. I looked at their file to see if they met with him. There's some notes about all that. That was there. So I didn't find any deficiency. If I had, I would have reported on it.
Okay. Your Honor, that's all I have.
Redirect.
I tend to be correct in saying briefly, because I'm hungry. Mr. Raven,
Yes, sir.
I understood Mr. Moore to ask if insanity was the only viable defense in this case. I don't know if I misunderstood that or not, but what would your response to that be? And I guess I'm looking at viable defense.
Well, I'll answer the question this way. It depends on how you define the word defense. A defense is literally, under Tennessee law, if you go through the various defenses, and then arguably there are affirmative defenses, so that's how we categorize them. But you go through defending your client, a viable way of defending your client. You use the tools that we use as lawyers. So the only defense under the statute would be insanity. The other way to defend the man would be through diminished capacity. So he asked me that question, and that was the answer I gave. And if you interpret the word defense in that context, then that is literally true. But the other viable way to defend the man would have been the diminished capacity as a corollary to the defense of insanity.
And diminished capacity requires the proof of a mental health or defect.
Sir?
And diminished capacity requires the proof, establishing the proof of a mental health or mental disease or defect, right?
For purposes of diminished capacity, yes,
Yeah.
you have to have expert testimony
Yeah.
for the judge to be able to charge it to the jury.
There was expert testimony presented at trial, right?
That's what you're required to do to present
Yeah.
diminished capacity, if that's your question.
There was no opinion that diminished capacity existed, but there was an opinion regarding the mental disease or defect, was there not?
Yes, yes.
Okay.
There was abundant evidence, and as the general pointed out, they didn't even contest that.
And as counsel said, that really wasn't an issue in the case. The wrongfulness was where they were going with their defense, with their prosecution.
Well, General, it wasn't contested. It's always an issue in the case. It depends on the degree of mental disease or defect. He may have had a modest mental disease, but it has to be significant. They didn't contest that issue, and there was abundant evidence of mental disease or defect in the record. Yes, sir, a lot.
So in your opinion, having reviewed the medical testimony, was there proof in the record of an inability on Mr. Reinking's part to form the necessary mens rea?
I think you could conceivably find that to be the case if you looked for it. You know, was there enough to trigger a jury instruction? That's the test. I don't know if there was. If you're asking me that, I don't know, because the doctors, I mean, the case law is pretty brutal on this. Unless the doctor says, point blank, the person has a mental disease or defect and he couldn't form whatever the intent was, unless you get that level of specificity, I don't think you're entitled to jury instruction. You got to have that proof in the record. They didn't have, that was not there, in my view.
Well, we had, the reason I'm sorry.
Go ahead, I'll follow up.
I mean, if you're asking me if there was enough to trigger a jury instruction, there was plenty of evidence of mental disease or defect. Did it have to do with his mens rea and state of mind? Yes, there was. There was a lot. But then there was abundant evidence. But what I'm saying is, it's fine to do that, but you have to have the jury instruction, because otherwise it's just testimony and it goes to the wrongfulness. A defense is no defense unless you've got proof in the record and the judge tells the jury, you need to consider this under the following rules. That didn't happen because the lawyers didn't have enough evidence of that. Now, was there proof that he didn't have this intent or that intent? Of course.
They didn't have it, or they didn't recognize it?
They
You're not-
testified about his mens rea, his mental diseases, his mental defects, and what he was thinking. There was tons of evidence about that. But you have to connect the dots to diminish capacity. And under the strict ruling of the Supreme Court, the doctor's got to say the magic words. Yeah, I think he didn't have the intent or whatever it is. Then it triggers the judge's obligation. I don't know if there was enough evidence in the record for the judge to have charged that. I don't think so.
But we do know that there were two experts who testified at trial.
There were.
And those experts said that he didn't appreciate the wrongfulness of his conduct,
That's what they said.
and not inability to appreciate the wrongfulness of the conduct. How does that equate with inability to form the requisite intent? Is that not a strong inference anyway to ask for a jury instruction?
You could have argued that, okay. Is there enough that that was a legally requirement? That is not within the purview of my testimony. I will not give an opinion on that, because that's a legal question that the lawyers can raise. Was it ineffective assistance of counsel for them not to have raised that? I did not render an opinion on that. Okay, whether the judge should have charged that or not, that is way outside the scope of my testimony. You can argue that as much as you want, but I'm
Should they
saying,
have?
should
Should
the
they have?
lawyers have tendered a special request on that in the absence of having put proof on? Under the conservative, narrow definition of ineffective assistance of counsel, it is my view that they did not render ineffective assistance of counsel by failing to ask the judge for a special request on that. That is, the law on Sixth Amendment is, that's what it is. I have to follow the law in my analysis. Whether the judge might have that, that's for you to decide. But did they render ineffective assistance of counsel? I'm not asking for that. I don't think so. And I didn't. You're asking me that, but I can't find that from this record. And the reason is because of the brutal rule requiring that the expert testify about all that and articulate that. And that wasn't done, so there wouldn't have been enough ammunition for to ask the judge to, because the judge would have said, well, where's the expert testimony? Here's what the cases say. That's what the general would have done. Okay? And it's, you know.
Looking at the diminished capacity instruction, there was no witness, no expert witness
No.
that said he couldn't form
No,
a mens
the
rea.
defense, you could make this argument as lawyers, but I'm saying from Sixth Amendment standpoint, they didn't have enough evidence in the record to have triggered instruction from a constitutional standpoint. They just didn't put the proof on. They didn't have it. And that, obviously they should have, and then that would have triggered the instruction. But your question in the abstract, did they render an effective assistance of counsel? By failing to file a special request on that, no, sir, they did not.
Well, Mr. Ramsey is weighing what you've said. Or was there any, if I understood your earlier testimony, they were deficient in not pursuing whether or not there was evidence to present on that issue?
Yes, sir, that's true.
Okay, so we're talking two entirely different things. What the record actually revealed at trial as to whether or not the instructions had been asked and given versus the fact that they didn't even pursue investigation of whether or not such evidence existed to present at trial.
Your Honors articulated that precisely. Under this record, there was no deficiency in them not even asking for the special request, because the proof didn't measure up. State would have objected. Can't speak for the court, but the court probably wouldn't have granted it because it just didn't meet that test.
Okay.
That's that. That's what whoever asked me that question.
Okay.
But whether they should have had the evidence there, of course, that was the deficiency, so as to trigger the instruction.
Right.
That
Two
is
separate
like-
areas, right?
They're very separate. They're very separate issues because you have to have the evidence and the instruction, and then you can argue to the jury, and then it's a jury question. That's how it works. You have to have both. And here they had neither.
I think my question in that regard was purely regarding finding the experts saying that he could not appreciate the wrongfulness of his conduct.
Right?
Did that equate to an inability to form the requisite mental intent? The intent, the mens rea
Okay. You can make that argument,
on
but,
appeal.
you're talking about the general intent here on wrongfulness, okay? Wrongfulness, to understand that what he was doing was wrong, not to have that responsibility. That is the complete affirmative defense. How that equates to the specific intent, it's a corollary. It's very similar. They're compatible. The evidence is very similar. But the law is you've got to have, the experts have got to testify that the man didn't have the requisite specific intent, not just wrongfulness. And unless you have those words come out of the doctor's mouth, you don't get the instruction. That's what I'm saying. That's what the law is in Tennessee. They didn't do that.
The lawyers at trial, did they look at, from your view of the record, did they look at the nature of the offense, the failure to not appreciate the nature or wrongfulness of their conduct? Did they look at nature, or did they just focus on wrongfulness?
My reading of the record, they just focused on appreciating the wrongfulness, and they didn't focus on the word appreciating, they just focused on the word wrongfulness. There is an important distinction between knowing and appreciating. I may have said this before, the law requires an appreciation. So I may know that if I jump off of this building, it'll kill me. I mean, the gravity will take over and I'll fall. I know that. Because of my delusion, I think I can fly, and I don't appreciate that I'll die. That's the difference. And appreciation is a much more nuanced definition. And here, they just focused on whether it's wrong or right. They didn't have very much discussion on the word appreciation. It's not just knowing the difference between right and wrong. You have to appreciate it. And this man's delusions were so profound, he may not have had the appreciation of that. So you asked me, what did they focus on? They exclusively focused on wrongfulness. I didn't see much discussion on appreciation. In fact, I don't think there was any.
Nature is basically a cognitive awareness of reality. Reality.
Under the way the case law talks about, yes. The lawyers didn't focus on that.
And the ability to form rational understandings as opposed to alien and...
Well, whatever that was, I'm just saying that the case law in Tennessee is not well developed as to what the nature of conduct is. They didn't address it in the proof, and so I don't need to voice an opinion on the status of the law there because it wasn't in the record. So I'm not going to I'm not saying that there was anything litigated on that one way or the other. That's based on the existing record. So they focused exclusively on wrongfulness, if that answers your question.
Should they have looked at nature as well? It's part of the jury instruction, right?
But the jury instructions talk about it. Should the lawyers have dealt with it? Because the experts didn't deal with it, they didn't develop it with their own experts. Is that a, constitutional issue there? I'm not gonna voice an opinion on that because there's no proof. I don't know what the doctors would have said. They didn't ask the doctors that question. So I don't know what the answer would have been, and I don't want to speculate on that. I mean, if they'd had a psychiatric evaluation that dealt with his neurological impairments and stuff, then you definitely get into issues of nature of conduct, but they never got into that. So I just don't want to voice an opinion on that.
The doctor's here. He could. You have reviewed, have you not, the medical opinions, psychiatric opinions of Dr. Speaker,
Yes.
Dr. Agarkar,
Yes.
and they both addressed the nature, or the inability to appreciate the nature of his conduct.
Yes, they do, both of them.
So evidence could have been presented to the jury on that issue had it been developed.
Yes, sir.
Had it
Your
been
question-
investigated.
okay. Your question to me, I want to be real clear about your question. You asked me, what was the issue they litigated? They litigated the issue of wrongfulness. You asked me if they litigated the issue of nature of conduct. They did not. Okay, they didn't ask the doctors any questions about it. There's no medical evidence in the record. That is the question you asked.
Yes.
Now you're asking me, in light of these other doctors' testimony, would my answer be different if that's what you're saying? There is evidence, if that evidence exists now, then potentially that is the kind of thing the lawyers could have done. They didn't do it, if that's what you're asking me. I'm only telling you what they did do and what they didn't do, and now the record shows medical evidence that the defendant didn't appreciate the nature of his conduct, which goes back to the problem that they didn't ask for another psychiatric evaluation after the first two psychologists looked at him. Had you had these two doctors now, a psychiatrist and a neuropsychologist, look at him, sure. But, Mr. Massey, that goes to the prejudice prong of what I'm
Yes.
trying to talk about.
My next question to you.
You have two issues. One is the deficient performance. They should have had the evaluations, without a doubt. Then the question is the prejudice. Was the defendant prejudiced by that? Of course. And now you have the evidence of these other two doctors to say, well, had he had this, this is what it would have been. So that answers the question of ineffective assistance of counsel on the nature of conduct or failing to do it. They never considered it. They never did it. They sort of like diminished capacity, okay? And your doctors have talked about diminished capacity too. That substantiates my opinion that had they had proper psychiatric evaluation, they could have had doctors say that the defendant didn't have or had diminished capacity. And the same thing in the nature of conduct. But that goes to the post-trial assessment of the failure of the attorneys. Your burden is to show would it have made a difference. And you've done, I suggest you've done that.
In viewing all of the documents,
Right.
in making your assessment of ineffective assistance of counsel, what is the biggest error you see? Is it diminished capacity, lack of investigation?
I mean, I don't want to grade the errors. I mean, to me, it's you either fall on one side of the fence or you fall on the other, and then you use them how they stack up at the end. I would say the diminished capacity is probably the most profound error in the whole record, for the simple reason that that goes to the fact-finding function of the jury. That's why we have juries. So the jury has to consider all the facts. The judge lets the facts in. He was very good about letting both sides put on pretty much whatever they wanted to. And then the jury considers it. That's what I said earlier. That's what justice is. You have a procedure, you put all the facts in, and the jury decides, and you just have to accept the result. But here, that facts were not all in front of the jury.
And had those facts been put in the record, had that proof been presented to the jury, there is a reasonable probability of a different outcome. At least second degree of a lesser included offense.
Do you have the test is there, do you lack confidence in the verdict of first degree murder, and there's a reasonable probability or possibility of a second degree murder conviction? The answer is yes. Had all these things been done, and the things that weren't done, not done.
And
yes.
had diminished capacity been instructed to the jury after having that proof, that there was, in fact, diminished capacity.
Mr. Massey, I'll answer the question this way. I have to consider the totality of the record, and I have to consider all of the issues, the Sixth Amendment issues. I have found some that were serious, but they didn't constitute. Considering them all, which I'm required to voice this opinion, I think that the result is in doubt and that a Sixth Amendment violation occurred. Was the diminished capacity by itself sufficient? I could never say that because you had these other things. The jury considers everything. That's what they're supposed to do. So to say, well, this made an impact or this didn't, I can't say that. But as a professional, which was the most profound issues? That clearly was diminished capacity, along with the other issues I've talked about.
Is there case law to establish that the reasonable probability of a lesser included offense meets the prejudice prong?
Absolutely. The Lori Zimmerman case, that was what they went off on, and the Supreme Court has adopted that in numerous other cases, yes.
And with diminished capacity evidence, then there's a reasonable probability the jury would have reached second degree. And that's why there's not reliability in the result.
The Zimmerman case holds that because they say when you're dealing with the degrees of homicide, there's a thin line between the degrees of homicide. Mr. Massey, is the only crime in Tennessee that has like 6 or 7 degrees. You know, burglary has 3, but homicide has multiple degrees, and you've got to find line between them. So that may not take much to roll between one or the other. So, yeah, when you're dealing with mens rea, the proof can be different, make a difference on the verdict, sure.
So standing alone then, that could constitute ineffective assistance of counsel.
It is, okay, my professional opinion, it is possible. My opinion has to be based on the totality of the record. I'm required to consider everything in its
And were there
totality.
multiple other errors?
Yes, on that issue, yes, on the Sixth Amendment problem.
And was there a plethora of prejudice?
Say what?
And was there a lot of prejudice? Plethora, a lot of it.
I think the prejudice was so severe as to render a question as to the reliability of the verdict. That's the only way I can articulate it.
Last area of questioning. if I understood you correct on cross, you said that there was proof of premeditation in the record. Right?
Yes,
And is that because objectively he shot someone with a gun, aimed at him,
that's part of it, yes.
and he drove there?
Yes, sir.
But because of his delusions, delusional thinking, would that be premeditation?
What I'm saying to you is under the definition of premeditation under Tennessee law, the delusions could have been negated, all of the judgment and reflection, which is what premeditation requires. It doesn't just require picking up a gun and shooting someone. That is intent. Intent to kill is a different element. Intent to kill under Tennessee law is that you do an act where you desire the result of death. That is what intentional means. But you also require, that's second-degree murder. But premeditation is an added element, which requires the other things that I discussed. That's beyond just the act itself. And there's plenty of cases that say multiple blows or multiple shots does not necessarily establish premeditation. It could show a rage or whatever. So that in and of itself is not conclusive of premeditation.
Is it safe to say then that the intent and the premeditation, both that were in the record, were based on his delusional thinking?
Ask the question again. Ask me the question again. I didn't understand it.
Is it fair to say that the proof that there was a premeditation and intent that you spoke of was based on, was looking at it, if you looked at it through his delusional thinking, it would not be criminal?
I still don't understand the question. Forgive me.
Okay.
I'm not understanding what you're asking. I want to be responsive.
Was the proof of premeditation and intent that you said was placed in the record,
Right.
would his delusional thinking would it equate with intent, for example?
It could. It could, because you have to ask yourself the question of whether intent is an objective test or a subjective test. And I don't want to get into all of that. But the question is did the state have enough evidence in the record of intent and premeditation? Yes. If you use a subjective analysis of those things, of considering diminished capacity and that sort of thing, delusions, that's also relevant to that. That's why it becomes a jury question. The proof was there, but the diminished capacity instruction was not articulated, and neither did the doctor. So was it the evidence there? Yes. But he's filtering all of this through his delusions. And Mr. Massey, that's the thing. We can't grade his delusions. We can't put ourselves in his brain. He's seeing the world in a different way than we would be. So that's part of the jury argument. So intent, premeditation may be something very different to a delusional person. That's why I go back to the thing. You can jump off the building and, I'll know gravity takes over, but I'm not going to die. That is, I think it's wrong because I can fly. That's what I'm saying. That's why you filter these things through the mind of the insane person. That's why you have to have the expert testimony to put those things together. That's the point. Okay?
Okay. Okay, this was the last question.
All right.
I'm thinking about the Overton case that you cited, where
Yes.
the judge, they ended up finding, based on the delusional person's perceptions, that it wasn't first degree, it was voluntary manslaughter.
Right.
So the assessment of whether or not the intent is based on how do I word this? I'm struggling with it. The assessment of intent is based on his perception,
That's,
is it not?
yes. It's based on his perceptions. It's one of the factors. That's true.
And there is evidence that he was acting in self-defense?
That was in evidence that, in his perception that he was.
And there was act,
Because of the delusion, in a sense, yes.
evidence he was being tormented,
Yes.
stalked,
Yes, that was in evidence.
tracked, aliens,
Yes.
and Taylor Swift, and,
Yes.
okay. All right, hang on one second, John, please. No other questions, thank you.
Rick Trump.
No, Your Honor.
Thank you, Mr. Reagan.
Thank you.
Be back over to federal court.
Yes, sir.
Is there any further proof?
Not from the defense at this time, Your Honor.
All right. State had proof?
No, Your Honor, other than would ask that the next numbered exhibit be essentially the record of this proceeding, the transcript of the trial, for Your Honor to incorporate.
What number is that? 11 or 12?
And Your Honor, we would agree that the court consider the entirety of the record of the case in the course of considering the motion for new trial.
The trial transcript that was submitted, did that include everything? I mean, opening statements, closing arguments?
The hard drive doesn't have the entirety of the trial transcript.
I have it, Your Honor.
I'm copying it to a drive right now to provide to the court.
Okay.
The full trial transcript.
Okay, but the full, I mean, sometimes the full trial transcript is only the evidentiary portion. Does it have the opening and closing?
What we had prepared does have the opening and the closing. We also had prepared, and we asked the clerk's office for this, any of the proceedings that were recorded in General Sessions Court, and we tried to get every single time the case was even for status in criminal court. We had those transcripts prepared, Your Honor, so rather than just the trial transcript, what I would like to do, if it pleases the court, is we will late file with the court the entirety of the transcripts of all proceedings in this case, both in General Sessions Court and criminal court.
So that'll be Exhibit 11.
Yes,
All, the record of both general sessions and criminal court.
yes, Your Honor.
Is both of them gonna be on that thumb drive?
He's gonna do it.
Yes.
I'm gonna do it. The defense will late file
It's gonna be on the thumb drive?
it. Yes, we'll late file it. Thank you. And Your Honor, of course, in addition to that, we also would ask the court to, of course, consider all of the trial exhibits and trial evidence and the filings in the case, any pleadings, any other documents that are on record with the court.
I would do that. That's one reason I was trying to get clarity this morning on this second amended motion. I couldn't really find any, I didn't find the original. But yes, I've got all that right here. Anything else at the moment?
No, Your Honor.
Y'all wanna go to lunch and come back and argue?
Whatever you want to do, or we can argue now, yeah, whatever the court's preference is.
Doesn't matter to me. Y'all want lunch or you wanna get it over with?
We would like lunch. Yes. There's a lot of people. Yes.
I've noticed that's been a popular decision this week, so.
Can I, the affidavit and report, the attorney, if I can order it.
All right, we'll see you back here about 2 o'clock.
Yes, ma'am?
On that thumb drive, it says gonna be trial transcript and what else?
The transcripts of all proceedings.
General sessions and trial.
I'm not met you yet. I'm sorry, I didn't hear you. Jay, good to meet you. I'll get it to you. Do you have, maybe, well, I can try to find a flash drive today. I'm sure somewhere in Nashville there's a flash drive.
I'm sorry. No. Don't.
Okay. You're just transferring everything out of this court, don't you?